Oh, excuse me, recording was not in progress. Okay, now recording. Okay. This is a good example of a 6-column table that works very well. I generally do fewer columns, but it's up to you folks how you like to do it. When in the law office too, do it in such a way that you and the other team members, other paralegals, lawyers, and so on, find useful. So this is a way of analyzing tort by tort, basically, to make sure that it works for you. So if you go in there, you can see where the person found it, what the person, in this case Brianna, thinks about it, and then certainly defenses and so on. Facts over here. So if a lawyer was going through this on a regular case, the lawyer would be able to skip down and say, well, let's make sure that we get these elements out there. I want to be able to refer to them quickly. Okay, those will always be in the third column. So it's just easily skimmable, so that's useful. And I've talked to lawyers, and they do like these kind of things. They like things that are skimmable, so the sources are available quickly. They may want to see the sources, or they may want to see a summary. It's really helpful, of course, during like a trial or something, and they want to quickly double check that the elements have been proven. We've done this in different forms of law. One of the problems that occurs is we get so involved in details and in arguing about certain details of evidence law, procedural law, which includes evidence law and civil procedure. You're arguing procedural points, but then you can forget about basic elements. Sometimes you get involved in details and difficulties, and basic elements get left behind. And then later on, the other lawyer smirks and says, oh, can we go into chambers? Well, excuse me, and this did not happen to me, but it could have. Had we not been prepared, had I not had a good staff, had we not gone over this and over this, and had good notes, good visual aids, they could have gone into chambers, talked to me and the other lawyer, talking to the judge, and said, oh, by the way, Mr. Olson did not prove all of the elements of the case, just some of them. I'm going to ask for a dismissal. And then what am I going to do? Call back to the office and say, get my malpractice insurance on the phone? No fun. It never happened. Why didn't it happen? What went right? What goes right when you don't have to make that phone call? And by the way, if the boss does get into very big difficulty, make sure the phone call gets made. Make the phone call. Because frequently things are not as bad as they seem in the panic. It may be to insurance, maybe to professional responsibility. Well, not chairman, but director office. Make the phone call. If something seems like it's going really, really bad, do not stall, delay, wait. And I'm advising you, I'm not advising you to do it on your own. I'm advising you to sort of hint, pass a note, something, because lots of these 4-alarm emergencies turn out to be not quite as bad. And every time that the phone call is made to the correct person, you minimize the damages, okay? The trouble, and don't let it get worse and worse and worse, okay? So I do want you to get into the intensity of high-level work, but then I want you, so emotionally, mentally, I want you, when you're in school, to sort of role play as being in this intense situation. Intensity and panic. Then role play calming down and doing the right thing. Is that making sense to folks? I'll say doing the right stuff. Now I had to make phone calls, and it turns out, of course, that I had done nothing that messed things up and so on, but it's still nice to get reassurance. But why didn't we have the really bad ones where we had to pay out bucks and where we had to have the real difficulty as opposed to the threatened difficulty? It's number one is, I suppose, would be the education, which is long-term preparation, right? Education is just long-term preparation, isn't it? For things that have not happened to us but have happened to other people. We aren't learning by our own experiences, but we're learning from others' experiences, okay? It's cheaper. It doesn't seem cheaper than anything when you're paying bucks, I'm sure, for tuition and so on, but it is cheaper in terms of not having to go through the trauma of getting involved in stuff that you do not fully understand. And I'm speaking both to attorneys and to paralegals. But number two is then preparation for each case. A lot of the intensity should happen before the final negotiation or the trial. It pays to be intense about it before the last minute. I always had a staff that was conscientious, and I would say time management was a key. Top staff, people, they save the day before the day comes. So in torts, of course, and certain other, basically lots of types of cases, and we want to focus on torts now, but lots of types of cases is you keep track of the elements that have to be proven. In class, we're frequently doing it for the very beginnings of the case when we don't know if we can prove all of the elements. In class, we work on elements super early in the case, right? One of the simpler ones that you could overlook and does come up in some cases is just the element of intent. What type of intent is required, if any, or what type of mental element? Is it carelessness? Is it intentional? Is it strict liability? Keeping track of that and not losing it certainly helps. And so coming up with the correct elements and then sticking with them, and then as facts come in, which element do those facts prove? which elements are we weak on? If we have a wonderful case for liability, which we worked on really hard, because we were really worried about losing the case on liability, but we do kind of a minimal job on damages. Where are we sitting with the case? Let's say that we advance it closer to the end of the case. Where are we sitting if we slacked off on damages, do you think? And just speculate. You don't have to be correct on this. We slacked on getting documentation for damages near the end of the case. Where are we? What do you think? I'm not saying lawyers commonly do this. I'm not accusing lawyers of slacking, whatever. I'm not accusing any particular lawyers of slacking on it. But there's always the first time the lawyer handles the case. Every lawyer started out having zero experience on a type of law. There is always a first time that they tried a case or that they negotiated a case. Yeah, there is evidence. And let's say that the lawyer and the staff do a brilliant job as far as some very difficult damages that are legally challenging to get. Getting damages, I won't say getting damages, but getting damage estimates and arguments, sophisticated legal grounds, okay? Forget about one of the chiropractors naturopath. You know, we're trying to get very big money for this person, but we forgot about a couple of the items. And let's say that it's a very large case, and those two items only amount to $15,000, let's say $12,000. You know, and we say, oh, we didn't, you know, we're going to try to bargain to get $640,000. What's $12,000? What is $12,000 to the client? They owe the bills. And let's say that it's ones that the health insurance company won't pay for whatever reason. They think it wasn't indicated, but we could argue for it in court. And Jody gave a hint. Yeah, it would come out of the client's pocket. And what happens, does the client understand about the brilliant part of this, where we did some very sophisticated work on the law? Does the client understand that this shows that the person is doing a good job? Aren't they going to look at they screwed up on this? The other possibility is if we're representing the defense side. We see that there's $12,000 worth, but that the insurance turned it down, and we didn't bother to ask for any explanations of why the insurance turned it down. What are the corporate types going to tell us? Oh, you guys do a brilliant job on things, but you missed that. You didn't really check into that $12,000 on whether that was legitimate damages or not, or duplicate that they didn't need to put in there. Are they going to say you saved us? You saved us $130,000 with brilliant work. You only missed checking on the $12,000. Yeah, they would be upset because their accountants are going to say this law firm does not know how to do insurance defense very well. You don't do the detail work. As far as we can tell, we're being charged, and they pay by the hour too. The insurance company pays by the hour, and they wonder if we're worth it, our firm. You know that maybe they'll call up another law firm and find out if they have room to take on another client. And am I overhyping? I don't mean to be overhyping, but they're not going to say that. They're going to say you folks need to get your act together. In case you ever work again. Okay. Yeah, Haley Buckman has a good idea in the chat, as do the other students here that are here with me. Doesn't matter what the monetary amounts are, it's affected the team missed details. I'm not putting it all on the paralegals, Haley, Jody, Amy, Brianna. I'm putting it on the whole team. Yeah, no, I'm not criticizing you. I'm just trying to, on the one hand, I want to heighten the drama. On the other hand, I want to put the ultimate responsibility on the attorney. So do a thorough job, but remind the attorney of which parts need more attorney attention. So it's good paralegal work to type out, not sure if we need to double check this. So and I guess I mean healthcare insurance. If we're working for the auto company, for instance, isn't it possible that if the healthcare insurance didn't pay, maybe we shouldn't pay either? If it was not medically necessary or it seemed to have nothing to do with the car crash? Do you see where I'm coming from? Now, that may not be a legitimate defense to that element of damages, but you don't need to make the final decision. Just invite the attorney to help you double check it, okay? Good paralegal work does not always involve, and frequently does not involve, you trying to make a final judgment and just leave something entirely out. If you are in difficulty, not uncertain, type out your uncertainty rather than leave it blank. Does that make sense to you? Like if you're doing if you're doing a memo or if you're doing a request for documents, you can put in red or bold or do a bubble comment. Should we ask for the should we also do some requests for documents to find out the exact nature of some of these bills or why they were necessary? Yeah, Haley is right. Same with fact gaps. Record the fact there was missing information that could help the case. Yes. And that's basically the same thing as we're talking. Yeah, that's the same thing as we're talking about here with this. If you do an over-inclusive asking for too many documents, you can, and you think that you may be asking for too many documents this week, you can just put a note on, should we ask for this? You know, something in red or bold or with a bubble comment so that the lawyer would realize that that's something that the lawyer needs to, that's not a standard form. That's something the lawyer needs to look at and think about. Right. Yeah, list that there is information missing. Yeah. Calculating damages to property is another one other than personal injuries. Fair market value. Fair market value is really just a calculated what an item would sell for. Okay, right, like Kelly Blue Book for cars would be fair market value. What is a for sale? A for sale is there's a nice car, but a person has missed only one payment on it, and then they are going to repossess it. So a person ends up selling the car for less than it's worth. It's been manicured. It's been gone over with a fine-tooth comb. You know, taken such good care of. It's actually worth much more than the loan. You don't let it go. You just do a forced sale, more or less. You sell it, and then you pay off the loan. But if you'd had time to sell it and hadn't been forced to, you would have sold it for fair market value, which would be like Kelly Blue Book. I guess it wasn't really a forced sale, but I never forgot. I owned a car for 1 year before I got married. And then when we got married, we realized we needed to be a one-car family. Only two of us. I could bicycle to law school or walk. I could run to law school, actually, across the bridge. That really dates this. That really dates this now that I think about it, I guess. I just think. So, yeah, I was a very young man then. But we didn't need one. And I went to two dealers, and I sold it for a fraction of what I had paid for it, a year before. But it was cheaper to sell it for less than fair market value than it was to miss several hours of law school in order to get maximum price. I really didn't want to miss any extra hours to try to go back and forth and sell it. So I just sold it to a dealer and took the bus back, I guess. But it was a Chevrolet Vega with the aluminum block engine. It was not going to sell for premium value anyway. So, but it was a nice little car while it lasted for me. I shouldn't say while it lasted, while I owned it. So here's a memory. This is purely a memory tool. Memory tools. What are the actual terms, the terminology? There's a term called general damages, and there is another one called special damages, or people call it special. And special damages, it makes it sound like it's something special or hard to understand. But special damages are actually what I would have, before I studied this, I would have thought those were the regular, ordinary damages. If you have specific bills for personal care, property repair, and other bills, those are special damages. Okay. If you think about physical harm, so on general overall losses, GOL, that's a memory clue. There is no such legal term, okay? If you don't like these memory cues, don't use them. Just use the term general damages and special damages, okay? If something is, if the jury has no real rule on how to calculate it, the judge does not tell the jury how to calculate it in exact dollars and cents terms, it's probably going to be called a general damage. Does that make sense? Now special damages, though, some of those need to be calculated out on an estimated basis by an accountant or a like lost wages. We don't actually know the exact amount of lost wages for most people because you are estimating, but it's still something that can be calculated with a calculator. General damages frequently are those that can't be calculated with a calculator according to some simple legal principle that's very easy to understand. But use the text to understand. I would urge you to look at the text for these. Really read and reread the text. To be able to explain types of damages, because that's going to help a lot. When the lawyer says, well, have you got the specials for me? Are the specials ready? If you have a nice list of specials and you're not sure that they all are specials, of course, again, flag those that you think are uncertain. Same thing as generals. Well, let's see. I had a list, the lawyer says, I had a list of the general damages we're asking for, and you have a list. And if you think something might not be a general damage, just flag it in some way, make it in red, bold, whatever, and put that right in there. I think some employees of law firms are afraid of seeming to be dumb, so they will not, they try to just act like they know everything. Don't do that. If you aren't sure, flag it, ask it, put it in writing. One problem lawyers have is lawyers get impatient and then they make it seem like they're not ready for questions. And I understand that, but for lawyers like that, I mean, work out a list of questions, okay? I would say document this with lawyers so that you don't get stuck with a question you never even asked. And Haley brings out that general damages are more concepts like pain and suffering, loss of consortium. There are ways to figure those, but they just are not built in. They cannot be built into the law and the judge is not going to command them. The judge is not going to command the jury to give someone $100 a day for pain and suffering. At least I would be surprised if the judge ever did that. Whereas if a person made $14.67 per hour, that may be a mathematical lost wage it may be a basis to calculate lost wages to an exact dollar figure. Not everybody has had civil litigation, so you may not be very aware of these things. I'm not going to go over those in detail. This starts the case. So those two start the case, summons and complaint, require an answer, and the answer is a formal written answer. To the facts in the complaint. Certificate of representation and parties sounds complicated, but it's very simple. Which lawyer represents which party, and what are the parties' names? Are there other parties other than the plaintiff and the defendant? Are there other third-party plaintiffs or defendants? So on. Notice of motion and motion for an issue that comes up of procedure. May have to have a motion hearing before the trial. An informational statement, basically stating where the case is, the status of the case, again, procedurally, basically, and court order, maybe any number of things, but it's signed by the judge. We worked on interrogatories and requests for documents and statements. Statements are documents in my view. Medical records, and like I say, let's assume that we've already asked the other side for a list. Providers previously, okay? Is this making sense to you now? We're going to be asking for records that have to do with damages. And one of the things that might worry you, which is not quite as worrisome as you think it is, but one question you might want to ask, does the other side need to supplement their responses? Generally, yes. But you and the lawyer should check your home states, okay? Okay. In all states, in the state and federal that I've seen, yes, they are. The general answer is yes. one of the things that is typically unnecessary according to the rules, but lawyers are doing it anyway. This is one I actually agree with. Normally, if the rules cover it, I say don't type it. You don't need to remind them that the rules exist when you're dealing with other attorneys on the other side, but it is okay to remind them to supplement responses as new information or documents come in. Okay, does that make sense? Normally, I don't want extra. I have a rule against it. Do not normally want you to type extra stuff for if it's not needed. If you've already asked for instance, if you already asked for full dental records from 2018 on, you normally don't have to also say, and supplement your responses for any new dental records after the date of this request. Normally you don't have to do that, but I would not be upset if a lawyer and paralegal decided to do that anyway, just to remind the other side. Okay? You may, you may do that. I understand why people do that. And it sort of depends partially on the judges in your area. Some judges, if you don't baby the other side a little bit, maybe they'd be too easy on them. So we're going to outline possible damages. And where do you find out about possible damages? Text and module lesson content, list of damage types. If you think that a damage type might apply but might not, what might you do with it? Leave it blank so that you don't look dumb, or type it and put a question mark, ask a question. What do you think? Yeah. Okay. Listed but question it. Yeah, absolutely. You need to be assertive and cast aside fear without being aggressive and hostile. Don't work at a high level for an attorney if you're afraid of the attorney. Okay. Okay. Yeah. Yeah, you don't want to take the position that I'm going to work for somebody who is so smart and so capable that they don't have time to explain anything to me, and get annoyed if I ask a question, even if I put a list of questions in writing. Then I'd say that's not a good place to work. If you put the questions in writing and you group them rather than ask one question every 10 minutes, I don't see why anyone who is reasonable would object to that. Yeah. But I can see where an employee, I didn't have employees like this, but I can see where an employee could be kind of like a client. Clients who call every 2 hours are not good clients, and they need to be told, would you group your questions and then come into the appointment with a list of questions, please? If the client is capable of doing that, that's a better strategy. The same thing with an employee. if I give an employee a big project, the employee should not be afraid to ask questions, but doesn't need to ask them every 10 minutes, okay? Mary Bowman was in a T-bone crash, and the details do matter. She was proceeding through a green light, which of course she was supposed to proceed through a green light, but the other car went through a red light. And that sounds kind of like negligence, but we're not focusing on the negligence itself. We're focusing on damages this week. On the damages part of negligence, right? Yeah. So she has certain kinds of injuries, lost wages. Permanency is a big deal for personal injury law. If they have permanency, they can get general damages for permanent loss of ability to walk well. Even slight disability can be compensated. Any question? I realize that you folks that are here with me are already knowing some of this stuff, a bunch of this stuff. Haley brought it out in the chat. Pain and suffering is different than pain and suffering, and the inability to walk well is a different general compensable damages, whereas the treatment bills are special damages. Make sense to the rest? Do you think that makes sense to people listening by recording? It's hard to absorb some of this detail on while you're listening recording. I would say stop, take some notes, stop the recording, take some notes, and then start it up again. Okay? And don't forget about the plain old fact that Mary's car was totaled. And you say, well, the insurance company will just cover that. We don't need to worry about it. Well, we maybe aren't going to worry ourselves sick about the car. I realize that. The insurance company will probably figure all that out, but still needs to be on our list. And you can just put it on the list. Again, question mark, do we need to deal with this as part of the lawsuit, or will insurance just voluntarily pay for the total car? I would include it on the damages list. But rehabilitation services, this is a little difficult because it says quite a while. Right. We don't know if first-party insurance is going to cover it or if she'll have to use third-party. First-party would be Mary's insurance, or whether she's going to have to try to get it through some of that through underinsured or uninsured from the other side and so on. Let's assume the other side does have coverage, but here's an instance, and I'm going to give that away, I guess. Terms quite a while. It doesn't say rehabilitation services for 16 months or 8 months, does it? Quite a while is kind of vague. It's where personal injury attorneys may not be willing to settle the case until we know whether her limp is really permanent or not. And that will frustrate Mary because we seem to be stalling, but we don't want her to accept a low settlement for something when she has a permanent injury, if we don't know for sure that it is permanent. Okay? The other side may have a medical expert that later on comes up and says, well, it's not going to be permanent. They're going to be able to fully fix that limp. And our side says, oh, no, they won't. But I'm just sort of giving you some extra stuff for it. You don't need to have written that down in notes. I'm just trying to get you to see how you analyze it. You're analyzing it as the case starts. After some more work on the case, you and the lawyer may change your minds on how exactly the damages are going to be calculated, how much is really going to be calculated. Okay? But that's one reason why we're doing discovery. I'm going to ask you a question back to interrogatories. Do you have to, and if you're listening by recording, write down in your own notes what you think. Do you first have to ask if someone knows something before asking the question? One of my examples was some lawyers like to type out, were there any witnesses? If so, please name give the following information for each witness. You know, name, address, so on and so on and so on, other contact information. Do we really even have to ask that? Brianna says no. And people, like I say, people listening on recording, same thing, try to answer this. You really have to do that? In friendly conversation, sometimes you do that. I understand that. But lawsuits are not a friendly conversation. They're a rule-based way of getting information. So just ask. Just ask them for a list of witnesses that they know about. If they don't know if there are any now, they can say, so far we don't know of any. But then they realize that under the rules, they'll have to supplement it later as they start to find witnesses. Yeah, Haley says, list the witnesses, correct. So we're being assertive, we're not being aggressive. It's not the same as the politeness you use. We are making demands, even when we call it requests, we're making demands, legal demands. Now, request for production, which we're doing this week, do you have to ask if they have any items before you demand production? For instance, Haley and Brianna say no. I agree with you. Is there a need to ask if they have any income tax forms for 2019 before asking them to produce them? No. Do you need to ask if they have a policy of insurance to cover the automobile before asking for a copy of the policy? No, you don't. Just for all policies. Yep. Now we're asking for policies. We're not asking for raw information. We want documents, photos, etc. Because why do we need someone's income tax forms? We need the injured person's income tax forms. Okay. And let me look here. And that's number 5. I'll show you here. For part 2, I'll make this a little bigger. Part 2, the person that hits Mary's car sent Jane Smart a request for production of documents, okay? So this is because they're not going to take Mary's. Mary says, "Well, my medical bills were $90,000, and there'll be another $130,000 before I'm done." The person that hit the car has gone to an attorney, probably one that's paid for by the insurance company. Okay. And they are entitled, since Mary is going to ask for all of these damages, they're entitled to all this information, okay? So they not only want tax returns, but they're going to ask for wage stubs, because we're asking for lost wages. You were switching sides. Part 1, you're working for Mary. Part 2, you're working for the other side. You're going to act as if that Mary is otherwise going to ask for too much money. We're going to double check whatever Mary is claiming. We're going to try to find the documents that would stop her from claiming extra money. We're going to cross-check. We're going to cross-check the medical documents for one thing. She has a limp and then moving her arm properly. If she asks for a lot of money for psychological harm, frankly, we are going to be kind of rugged and mean and ask her for stuff that she does not want to tell us about from previous to the accident. Sounds kind of mean, but if you look at it from the point of view of somebody who has to pay insurance premiums, you probably do want your insurance company to make sure that they're not paying for counseling that's not anything to do with the car accident. Does that make sense? Yeah. Yeah, and I have good stuff in chat. I wish you were all here, because you have really good comments. Really good comments in the chat, and I can't go over all of them because of time, but basically there's a reason to ask Mary's side for financial, especially wages, where she is asking for lost present and future wages. And other financial, such as tax returns. Do you know, when I say tax return, I don't mean the money that comes back. Like somebody got a tax refund of $2,000. I don't want that. What I want is the tax forms that the IRS calls a return. So I will have to fill out a 2020 tax return to both the IRS and a official Minnesota Department of Revenue tax return for my income for 2020. Okay. Do at least 5 requests for production. Each request should relate to medical or automobile. Do not do canned ones. you find on the web. Do your own drafts. It isn't because I want perfect. I want your personal drafts. Even if you feel that somebody else's would be better, because I want you to exercise your own brain and drafting. Because you're developing your own drafting skill. And good comments. Thanks for the chats and stuff. I'm not necessarily going to comment on all the chat stuff, which is good stuff, because they're not questions for me particularly, I don't think. Discussion. Oh yeah, this one's difficult. The discussion is difficult because of the ethics of it. I would say it's at least challenging. And here's your live classroom magic words. This is your last point getting one, whatever. I will do one next week as well. Yeah. But I've got good questions or good comments in the chat. And next week we'll talk about malpractice, implied consent, and various other things. But that's all we're going to do today. I'm going to turn off recording and see if there's individual questions, because I said, well, it starts with the discussion. I've got a question in there. Discussion, more of an ethical discussion. It's both. You want to talk about the technicalities of what has to be disclosed and talk about the ethics of it, I would say. Okay. I actually used, when I did mine, I used the Rule of Civil Procedure, Federal Rule of Civil Procedure 34 and the Minnesota Rule of Civil Procedure 34, which is not an ethical rule, but it's if you don't follow, if you disregard, well, I shouldn't type into the chat because the recording people can't see it. But basically, if you disregard the civil rules on purpose, are you being ethical? I guess I'm going to put it that way. I guess that's the thing. The concealment of information. I think we exaggerate the value of concealing information. Again, this is where legal ethics and sort of friendship ethics are different. Problem is you've gotten some stuff that is related to the medical issues that is hurtful, but you at least have to talk to the attorney that you work for and see if there's some way to finesse this so that it does not become a public part of the case. It can probably be sealed. You can probably get an agreement from the other side that it's a sealed record, but if they have a legitimate right to it, we cannot just conceal it. I would find this, I suspect that the person creating the course maybe ran across something like this in the past. I have never run across it in a tort lawsuit, but we did have situations in like paternity cases where we didn't really want to talk about all of the facts, but we're kind of stuck with the truth. Does that make sense? If you try to win by lying, or you try to save somebody by telling a lie that would affect a case, that creates a big problem. On the other hand, judges and lawyers are sympathetic with people as long as they know enough to be able to negotiate a matter truthfully with the correct facts. As far as being confidential and so on, lawyers, insurance companies are not such bad people as we sometimes think they are. Does everything need to come out in open court? No. And most tort cases are settled, not contested in open court. It's almost too few are being tried, actually. They're settled so overwhelmingly rather than tried. And part of it is maybe due to good pretrial preparation that it's not that they're not preparing for trial, it's that perhaps that they're preparing for trial so well that they don't have to try it because both sides can see how it would come out. And so it's kind of over. So that would be, I should say, it's easier when both sides are well prepared. It is easier to come out with an agreement than it would have been in the old days when people could surprise the other side. I'm going to stop here, and then I will see if the folks here have any questions having to do with the chat items that are not necessary for everybody.